This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about Chutzpah. That's Yiddish for unmitigated gall, where a criminal sought disability benefits because his crime was discovered and prosecuted and he became depressed. A claim of disability because of stress of an arrest and conviction is not something that is insurable, nor should it be, especially when the policy contains an exclusion for criminal conduct. Jason Brand appealed from the judgment of the district court entered in September 30, 2021, challenging the court's dismissal of Brand's counterclaims for breach of contract and breach of the implied covenant of good faith and fair dealing. Brand claimed Principal Life Insurance Company failed to pay him benefits under his disability insurance policy. In Principal Life v. Jason Brand, the United States Court of Appeals for the Second Circuit on November 30, 2023, resolved the dispute. The words and phrases in a contract of insurance must be given their plain meaning, and the contract must be construed to give full meaning and effect to all of its provisions. Straining a contract's language beyond its reasonable and ordinary meaning will not be understood to create an ambiguity and therefore favor an insured's claim. All provisions of a contract must be read together as a harmonious whole. Courts may enforce an exclusionary clause only when it has definite and precise meaning, unattended by danger of misconception and concerning which there is no reasonable basis for a difference of opinion. Whenever an insurer wishes to exclude certain coverage from its policy obligations, it must do so in clear and unmistakable language. The policy issued by Principal contained an exclusion for criminal activity that states, quote, "This policy does not pay benefits for an injury or sickness which in whole or in part is caused by, contributed to by, or which results from your commission of or your attempt to commit a felony or your involvement in a legal occupation." Principal Life contended that the exclusion entitled it to defend Brand's 2014 claim for coverage. As to the applicability of the criminal activity exclusion, Brand premised his November 2014 claim for disability benefits on his assertion that he was totally disabled by extreme anxiety that began in July of 2014 after a warrant was served on him by officers of the New York State Attorney General's office. The application cited no other cause or type of disability. On February 8, 2016, about 15 months after filing the application, Brand entered into a plea agreement in which he admitted to committing in connection with his businesses, and between January 1 2009 and March 11, 2015, the felony crimes of enterprise corruption, insurance fraud in the first degree, and grand larceny in the second degree. Brand stated under oath that he committed enterprise corruption, insurance fraud, and grand larceny in the period before he submitted his disability claim for extreme anxiety. Brand, without merit, contended that it was the criminal proceedings brought against him, not his commission of several felonies, that were the proximate cause of his disability. Even if the criminal proceedings triggered his most extreme anxiety, it was Brand's commission of the felonies, commission of the crimes that led to those criminal proceedings that in turn led to his disabling anxiety. He wouldn't have been anxious at all if he got away with his crimes. Brand's 2014 claim for benefits was barred by the criminal activities endorsement, and Principal Life was within its rights to reject the claim. The court affirmed so much of the judgment as granted Principal Life's motion for summary judgment, dismissing, based on the criminal activities exclusion, Brand's counterclaims for breach of contract and breach of the implied covenant of good faith. However, the district court erred in dismissing the remaining claim asserted by Principal Life, asking to reconsider Principal's request for rescission. So the court sent the case back to the trial court to deal with the rescission request. In my opinion, of course, misrepresenting material facts to an insurer when acquiring a policy allows the insurer to rescind the policy. Principal established that Mr. Brand was a criminal and denied his claim appropriately. It doesn't want him as an insured anymore and sought rescission, which the Second Circuit was unable to rule upon, so it returned the case to the trial court to decide whether rescission was appropriate, because it appeared that he lied when he acquired the policy because he was involved in a continuing effort of crime, including insurance fraud. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, plus access to the more than 4,670 blog postings. You can also subscribe to the videos for free on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button at YouTube or the Rumble thumbs up button at Rumble. And if you're interested in more detailed information about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.